Friends, I welcome you all to lecture number 1 of the Limited Liability Partnership Act 2008. This is part of the CA series sponsored by Shrijendra Exxon. I am your mentor, Shekhar Gehlot. Okay, so this is a flow chart what we are going to discuss in the Limited Liability Partnership Act. Okay, first of all, we'll be faced with the introduction. In this introduction, we will discuss what is the meaning and concept of a Limited Liability Partnership Act. You see, it is a very recent act. Okay, this is just 2008. If we go to other acts like Company Law Act, now we have a 2013 Company Act, but the rules or the law regarding the regulation of Companies Act has been there in India since like more than 100 or 150 years. Similar is the case with the Partnership Act. It's also of year 1932. Okay, but this is a very recent and a very fresh concept which is introduced in India in year 2008 itself. So, what is the meaning and concept of a limited liability partnership? What are the advantages? Okay, definitely it must be giving us some advantages. Otherwise, what is the requirement of bringing a new law? Okay, we bring a new law only in order to provide some advantages which were not available in the other structures of the law. Then we'll discuss the characteristics. What are the characteristics? I mean, what are the features of a limited liability partnership act? That is the introduction portion. Then we will do how you have to incorporate. If you want to set up a limited liability partnership, how do you do that? Okay, what is the procedure? Is it smooth or is it a rigid procedure? Is it a flexible procedure or is it very strictly followed procedure? We'll understand it. Then we will try to differentiate, okay, find distinction between limited liability partnership and other forms of entities available in the law. Okay, so this is going to be our course syllabus for this particular coursework of Limited Liability Partnership Act. That is also in short form known as LLP, Limited Liability Partnership LLP Act. Okay. The introduction is the Parliament passed the Limited Liability Partnership Bill. Okay, we all know how law comes into picture. First of all, there is a bill. Okay, a bill originates either in Lok Sabha or Rajya Sabha. Okay, first stage is a bill will be originated in either house of the Parliament. We have two houses, okay. Bicameral legislation we have Lok Sabha, that is House of People, or and Rajya Sabha, that is Legislative Council, okay. Council of State, Council of State is it is also known as the upper house, and Lok Sabha is known as the lower house as well. The distinguishing feature between both the houses is the color of the carpet and seating. It is shown to be having a green carpet and green seating arrangement. It has a red carpet and a red seating arrangement. So a bill means a piece of paper on which something is written, which the government is trying to frame into a law. Okay, so bill will originate either in the Lok Sabha or in the Rajya Sabha. Either house it will be originated. So the LLP bill was passed on 12th of December 2008. Okay, that means it was on 12th of December 2008. It had completed all the stages of becoming a law. Okay, of becoming of passing from both the houses. Okay, first of all it will originate in one house, then one house such as Lok Sabha will pass it with a simple majority, then it will go to Rajya Sabha for consideration, then Rajya Sabha will pass it with a simple majority, and when it is passed by both the houses, then it is sent to the president for his consideration and for his assent, for his acceptance. So on 12th of December 2008, the stage The stage of passing of the bill from both the houses was complete and it was forwarded to the President of India. The President of India assented the bill on 7th of January 2009. Okay, 7th of January 2009. That is why the bill is called Limited Liability Partnership Act 2008. Though it received the President's assent in 2009, but because it originated in 2008 and was passed by the House of both the Houses of Parliament in 2008 only, so the bill will continue to be titled as 2008. And many of its sections got enforced from 31st of March 2009. That means immediately within a couple of months the law came into picture. Okay, so this is the brief history of Limited Liability Partnership Act, how it became a bill. How it became a law from the bill. This act have been enacted to make provision for the formation and regulation of limited liability partnerships and for matters connected therewith or incidental thereto. This is the preamble of the act. When we did preamble in the constitution, we understood preamble is a peeping window. Okay, preamble is a peeping hole or a peeping window. It provides you an access to what is contained in the act. Okay, what is this act all about? So without reading the whole of the act, some acts may be very voluminous, you can understand the objectives of the act. So what is the object of this act? This act have been enacted to make provision for formation and regulation of limited liability partnerships and for matters connected therewith or incidental thereto. So the object of this act is setting up of limited liability partnerships and regulating the conduct of limited liability partnership and whatever matters which may be connected or incidental, okay, which may be naturally coming up along with the formation of a LLP. All these matters shall be taken care by this particular act, that is the preamble of this act. Preamble or say objective clause, objectives of this particular act. The LLP Act 2008 has 81 sections and 4 schedules. Now, brief discussion about the schedules. Okay, now it has 4 schedules and 81 sections. We will read in brief about these sections. Okay, we will not understand these sections in a section wise manner, but we will understand the law in a broad framework. Okay, broadly we will understand the act as to what this act is trying to signify and bring new, and it has 4 schedules. Let us read them briefly. The first schedule, okay, that is the first out of 4. The first schedule deals with mutual rights and duties of partners as well as limited liability partnership and its partners where there is absence of formal agreement with respect to them. Okay, so the first schedule starts with the mutual rights and duties of partners because it's a partnership, it's a limited liability partnership. Okay, a partnership which is having a limited liability. Earlier we discussed in the Partnership Act that a partnership has a unlimited liability and the partners also have an unlimited liability. Their personal assets or their personal wealth is also supposed to be liable for the liabilities of the firm. Okay, but here we are having something else, a new kind of partnership, which says the partnership is there, but this partnership is having a limited liability. Okay, that means the liability is going to be limited. Okay, so the first schedule deals with the mutual rights and duties of partners. Okay, as well as limited liability partnership. What is a limited liability partnership and what are the rights and duties of partners and its partners where there is absence of formal agreement with respect to them. So when sometimes the partnership is there, like we discussed, a partnership can come into picture even without a formal agreement. Okay, but can a limited liability partnership come into picture without a formal agreement? Okay, we'll know it later on. The second schedule deals with the conversion of a firm into LLP. Okay, conversion of a firm into LLP. Firm here means a firm means A firm means a partnership firm which came into being as per the governing provisions of the Partnership Act 1932. Okay, so whatever entity comes into picture upon the operation of the Partnership Act 1932 shall be known as the firm. But whatever entity comes into picture upon the use of the provisions of LLP Act shall be known as LLP. Okay, Limited Liability Partnership. It is distinguishable from the firm, but we will see the distinguishing features or striking features later on. The third schedule deals with the conversion of private company into an LLP. Now see how flexible this act is going to be. It has a provision for converting a partnership, okay, which has been set up in the Partnership Act 1932. You can convert such firm into an LLP. How flexible this is, isn't it? Plus, not only this, it also at the same time allows you to convert a company. Okay, you can convert a private company into an LLP, into a limited liability partnership. That means now you are trying to bring a company and you are trying to change it to a partnership. This kind of flexible was not allowed by any other act earlier. This is the striking feature or a very new feature or a welcome change of the limited liability partnership, and that it smoothly, okay, and very flexibly, very easily allows conversion of one form of entity into another form of entity, that is a limited liability partnership. The fourth schedule deals with conversions of unlisted public company into LLP. So not only a private company but also a public company which is unlisted, it can also convert itself into a partnership firm, a limited liability partnership firm. Okay, see how smooth and efficient this law is going to be. So now, can you convert a public listed company into a LLP? The answer is yes, but for that, first of all, you will have to get your listed company delisted, okay, or unlisted. Okay, yes, the answer is yes. Even a listed company, okay, so listed company is definitely a public company. Even a listed company can be converted into an LLP, but for that, you will have to first get that listed company delisted. Okay, that means you will seek a delisting of the stocks or shares of the securities of the company from a recognized stock exchange. Then only you will become an unlisted public company and you can transform yourself into an LLP by following the procedure established by the law through the Limited Liability Partnership Act 2008. The Ministry of Corporate Affairs, that is MCA, we know it, MCA in abbreviation, Ministry of Corporate Affairs, that is the governing body of all the companies. Ministry of Corporate Affairs is the governing body or the parent body in India. Okay, and the Registrar of Companies, ROC. ROC is the agent of MCA. MCA is the principal, ROC is the agent. Are entrusted with the task of administering the LLP Act. Now that means this LLP Act also comes under the framework of Ministry of Corporate Affairs and Registrar of Companies Act. Okay, it also comes in the sphere of Ministry of Corporate Affairs. The central government has the authority to frame the rules with regard to LLP Act 2008 and can amend them by notification in the official gazette from the time to time. Okay, the central government has the authority, okay, to frame rules. It can frame rules, some rules regarding LLP Act, and also can amend. Amend means you are altering, you are changing, you are modifying. Either you are deleting, adding, or doing something else with the rules by notifying them in the official gazette from time to time. It is also to be noted that Indian Partnership Act 1932 is not applicable to LLPs. So now we use the word partnerships in the LLP. The full form of the LLP, like we know, is Limited Liability Partnership. So the P here stands for partnership, but that is a significant change, a significant shift that for the first time there is going to be a partnership in India which is not going to be regulated by the Indian Partnership Act 1932. Okay, so the provisions of Indian Partnership Act 1932 shall not be applicable to the LLPs. LLPs are the limited liability partnerships.
It's 7 o'clock.
Need of the new form of limited liability partnership. Now, many of you must be thinking that we had a new Companies Act. Okay, or yes, when this when this act was passed, we did not have a new Companies Act, but we still had a Companies Act 1956. We had a Companies Act 1956, and we also had a Partnership Act of 1932. Okay, so we had the laws for companies as well as for the partnership. So, what was the requirement of bringing a law known as the Limited Liability Partnership Act? When you already had laws for forming up of partnership as well as for forming up of company, then what was the need for bringing a new law? Okay, let us read. The lawmakers envisaged the needs for bringing out the new legislation for creation of the limited liability partnership to meet with the contemporary growth of Indian economy. This is the first objective of bringing the new law to meet with the contemporary growth of Indian economy. Okay, contemporary growth means modern growth. Okay, because the Indian economy in the recent years has grown by spiraling leaps. Okay, like earlier when it used to grow by 2 to 3%, recently it has grown by enormous percentage. Okay, and now we can see a lot of millionaires and billionaires and young people who are entrepreneurs in India. Earlier this all was unheard of. Okay, only few business houses were successful in India, but now we see a lot of successful young entrepreneurs in India and a lot of commercial activity going on in India. And it won't be wrong or a overstatement if I say that this 21st century in which we are living right now will belong to, or it already belongs to the India, okay, and to the Indian economy, though we are suffering a tragic time right now, but this too shall pass. A need has been felt for a new corporate form that would provide an alternative to the traditional partnership with unlimited personal liability on the one hand and the statute based governance structure of limited liability company on the other hand, in order to enable professional expertise and entrepreneurial initiative to combine, organize, and operate in flexible, innovative, and efficient manner. Now it says that a need was felt for a new law which will synthesize or which will bring harmony between the two laws. What two laws we previously had? We had Indian Partnership Act 1932 and then For the companies, we had Companies Act. Now, Companies Act allowed people to have a limited liability company, a company whose liability is limited. And on the other hand, Partnership Act allowed people to enter into a partnership, but the partnership had a unlimited liability. So this was a race between a limited liability of a company and the unlimited liability of a partnership. And in order to find a common ground, okay, between both of them, this Limited Liability Act was brought in. But why do we need a common ground? Why was there a need of finding a common ground between Partnership Act and the Companies Act? Because of the growing modalities of the business, growing opportunities of the business. Now, Partnership Act, if we see, and we have discussed as well, it has a unlimited liability. The liability of the partnership is unlimited, and the liability of partners are also unlimited. So many people were finding it difficult to set up a partnership because partnership, first of all, comes into picture due to mutual faith and confidence between people. And then later on, all partners were agents of the firm. So that means act of each partner was capable of binding the firm. So when the firm was getting bound up by the acts of people, okay, then partners were always afraid of this unlimited liability thing. Okay, people who wanted to grow a business, who were entrepreneurs, okay, who had the skill set to compete in the new India, and they had guts to do so, but they were always afraid of the law, this unlimited liability. Okay, no one likes to have unlimited liability in the business environment because the anything can happen, and in the case of eventuality, everything is at the stake, even the personal belongings are at the stake. So people were very much afraid of unlimited liability. Then there was a solution for limited liability. When people found that we are afraid of unlimited liability, they found the solution in the Companies Act. They found the solution in a company company provided the clock of a limited liability. The company provided the clock of a limited liability. So those entrepreneurs who were not comfortable in having an unlimited liability in a partnership and wanted to have a limited liability for themselves, they had to opt or they had to go for a Companies Act. Okay, when you go to the Companies Act, if you have seen the Companies Act Bare Act, it is having more than 450 some sections. So that means it's a very voluminous law. It's a very big law. Okay, and it has a lot of procedures and formalities, which requires a lot of trouble, a lot of hiring of professional people, and a lot of expenditure on just maintaining the company, just maintaining the legality of the company. You were supposed to incur a lot of expenditure. Okay, and there was tough rules and regulations. Okay, so the Companies Act was full of or is full of technicalities, complex structures, difficult to meet legal requirements, expensive outlay. Okay, so company was so the people who wanted limited liability, they were going for private companies, but private companies they were finding these issues which I just discussed. So this thing was stifling the growth of Indian economy and as well as the growth of the aspiring Indian. And now, like I just discussed, that this century belongs to India and to Indians and to the Indian economy. Okay. So the lawmakers thought that we should find a common ground. We should find a common ground between partnership and the Companies Act. So what is that common ground? That common ground is LLP, Limited Liability Partnership Act, is that hybrid or the common ground between Partnership Act and Companies Act. It is the common ground or the hybrid. It means it allows you flexibility of a partnership. See, partnership is very flexible, like we discussed in the partnership law. Most of the partnership act is not applicable to you if you are having your own agreement with the partners, written agreement. So, in the case of a written agreement or an oral agreement for that matter as well, so many provisions of the Act of Partnership Act were not applicable to the firm. That means law is very flexible. It gives a lot of space or flexibility to those entrepreneurs who have come together and want to do some business. But the issue was the liability was unlimited. Okay, but Partnership Act otherwise is very flexible. Now, unlimited liability can be limited only going to the Companies Act, but the Companies Act, on the other hand, is very strict, very technical. Okay, and you have to comply with so many requirements that it used to be frustrating for new people. So now you have an LLP, which is a hybrid. That means which is a combination of both, where you have flexibility as well as limited liability. Okay, limited liability. So now what the law has tried to done or achieved from LLP Act is it has strike a balance between both the acts, LLP, both the acts, Partnership Act as well as the Companies Act, and that is the hallmark of the Limited Liability Partnership Act, and that is the reason why we have a Limited Liability Partnership Act. You give it a reading, okay, and then we will start discussing within a minute. The Limited Liability Partnership, or LLP as we say, is viewed as an alternative corporate business vehicle. It is an alternate alternative corporate business vehicle. Alternative to what? Alternative to companies law. It provides the benefits of a limited liability but allows its members the flexibility of organizing their internal structure as a partnership based on a mutually aligned agreement. That means now you are not bound to follow those shareholder meetings, AGMs, and all the requirements of the company law. Now you can have a very simple structure as per your own understanding and at the same time have the benefits of limited liability. Voila, what a structure! The LLP form enables entrepreneurs, professionals, and enterprises providing services of any kind or engaged in scientific and technical disciplines to form commercially efficient vehicles suited to their requirements. Okay, you can have commercially efficient vehicles as well. Like I discussed, a lot of formalities in the Companies Act. When a lot of formalities, that means you have to spend a lot of money for maintaining a company alone. But now you have a commercially efficient vehicle. Okay. But now you have a commercially efficient vehicle where you can save your cost and utilize that money, that extra money in running the business, and as well as you can have the freedom of limited liability. Owing to the flexibility in its structure and the operation, the LLP is suitable vehicle for small enterprises and for investment by venture capital. Venture capital means people or organization of people who are providing fundings to startup ideas. Okay, that is called a venture capital. Okay, so you are able to have small enterprise or you have it is just trying to so we are trying to boost in cutting the long story short, we are giving a boost to startups. Okay, to startups, and I hope you all understand what is a startup. To these startups, we are giving a boost so that India actually is the new age country. Clear? Meaning and the concept. An LLP is a new form of legal business entity with limited liability. Okay, it is an alternative corporate business vehicle that do not only gives the benefits of a limited liability at low compliance cost, but allows its partners the flexibility of organizing their internal structure as a traditional partnership. Now you can have the benefits of both a company as well as a partnership. So you have good sides of the both. Okay. The LLP is a separate legal entity. Now it is a separate legal entity as well. In the case of partnership, when we discuss partnership, we realize that a partnership, even if it is registered, okay, a partnership, either it is registered or not, it was not a separate legal entity. The face of the partners was the face of partnership, but here, in this case, that is not okay. A limited liability has its own independent legal entity. While the LLP itself will be liable for the full extent of its assets, the liability of partners will be limited. Just like a company, company's liability is unlimited, but the shareholders have a limited liability. Similarly, LLP's liability will be unlimited, but the liability of partners in an LLP shall be limited. This is a very welcome shift. LLP is an alternative corporate business form that gives the benefits of limited liability of a company and the flexibility of a partnership, like we have already discussed. Since a limited liability partnership contains elements of both a corporate structure as well as a partnership firm structure, LLP is called a hybrid between the company and partnership. Hybrid means having the features of both, having the positive features of both. That is called a hybrid. So LLP is a hybrid between a company law as well as a partnership. Now this is a features. These are the characteristics of the limited liability partnership. We give a brief reading to them and then we will discuss them in detail. So what are the five key features or the salient features of the LLP? New form of business, legal business entity with limited liability. Okay, it has a limited liability. Alternative corporate business vehicle allows the partners the flexibility of organizing their internal structure. That means it is flexible, it is new, it is alternative, it is new, it is alternative, it is flexible. Liability of partners will be limited, it is limited. LLP itself will be liable for the full extent of its assets. It is responsible as well. Okay. We cannot say that it is a highly irresponsible structure. No, the structure is very responsible and a flexible and an adventurous structure for the young entrepreneurs or those who have small investments and they want to start up their own without going big, okay, without having big fundings. Characteristics, salient features of LLP. LLP is a body corporate. Section 3 of LLP Act provides that an LLP is a body corporate formed and incorporated under this act and is legal entity separate from that of its partner. That means now we are bringing the concept of corporate will. Bringing the concept of corporate will. And if you remember, the concept of corporate will we discussed in the Companies Act. That means it is a separate entity from its partners. Okay? It is a separate entity from its partners, which means it can have its own independent property. It can have its own independent property. Okay? It can sue and be sued in its own name. Okay, it has its own seal, its own common seal. Okay, these are the features of a corporate will. It is separate from its owners. There's a will which separates the partners and the partnership. Perpetual succession. Okay. Now in the company's case, we studied that a member may come and a member may go, but the company will stay forever. Okay. That means in the case of partnership now, but the LLP goes on forever. Okay, it is just like a company. Even if the all partners die in a plane crash, there are 3, 4 partners in LLP. Both, all of them will die in a crash, in a car crash or somewhere, some unfortunate incident. The LLP will not come to an end automatically. The LLP is having a separate legal entity, separate from its partners. It has a perpetual succession to the infinity. It will go on forever till the time it is not wound up legally. It is a creation of the law, so it can be dissolved only by the operation of the law. Okay, individual acts of partners have no impact on the LLP. The LLP can continue its existence irrespective of the changes in the partners. Now, in the Partnership Act, we saw that even a small change or a slight change in the partnership, like one partner is going out or another partner is added, or if some partner has become insolvent, or a partner has died, or a partner has retired, or a partner has sold his share, in those cases, okay, the partnership would automatically come to an end. The firm may continue, okay, the firm may continue in the Partnership Act, but there will be reconstitution of partnership, there will be a change of partnership, okay. But in this case, there will be no such impact at all. The LLP will remain similar, irrespective of incoming partners or the outgoing partners. Death, insanity, retirement, or insolvency of partners has no impact on the existence of LLP because it breathes on its own. It is capable of entering into contracts and holding property in its own name, like we just discussed here. It can enter into contract, it can sue, and it can be sued in its own name. It can have its own bank account, it can have its own property. Okay. Separate legal entity. The LLP is a separate legal entity and is liable to the full extent of its assets. Okay, but liability of partners is limited to their agreed contribution in the LLP. In other words, the creditors of LLP shall be the creditors of LLP alone. If we see it in contrast with the Partnership Act, the liability of firm was not the liability of firm alone. The liability of firm was the liability of partners as well. But here, the liability of LLP is liability of LLP alone, and members have a limited liability to the agreed contribution. When you form up an LLP, you frame a partnership deed. In that partnership deed, you can agree upon a liability which every partner will have to fulfill. Okay, and your contribution ends there, your liability ends there. The LLP shall continue to have a unlimited liability, but the partners will have a limited liability only. That is a key feature of the Limited Liability Act. Mutual agency. Now, what is the impact on the mutual agency? Like when in partnership, we read or we understood that there exists a relationship of mutual agency between partner and the firm and partner and another partner. That means a partner in a partnership firm was both a principal as well as an agent. When a partner was acting as his own, he was acting as an agent. And when some other partner is acting for the firm, he is acting as a principal. Okay. Now let us see what is the change in the mutual agency feature in the Limited Liability Partnership Act. Further, no partner is liable on account of the independent or unauthorized actions of another partner. Now, this is a welcome shift. Now, no partner is liable on account of independent or unauthorized actions of a partner. Now, in the Partnership Act 1932, even for the unauthorized acts, the other partner would have been liable by the virtue of implied authority of partners in a Partnership Act. We read that a partner has an implied authority and he can bind the firm and other partners through his actions, even if illegal or unauthorized. But here, if he is doing some unauthorized actions or independent actions, his actions will no longer be binding on another partner. Thus, individual partners are shielded from joint liability created by another partner's wrongful business decisions or misconduct. Okay, in the Partnership Act, we read in Partnership Act, the partners were liable both jointly as well as independently. Jointly as well as independently. But what is the change in mutual agency here is, in other words, all partners will be agents of LLP alone. No one partner can bind the other partners for his actions. Now, the partners are liable personally only. Okay, and the relationship of agency is shared only with the LLP alone. Okay, that means now a partner is an agent or the principal. Sorry, LLP is the principal. Now a partner is agent of LLP alone. He is not the agent or the principal of another partner. So when he is acting, then he is acting either for himself or the LLP. But he is not acting for all the partners or any one of the partners at all. This is the welcome shift in the LLP Act. Now we have something called LLP agreement. Just like we had partnership deed in Partnership Act 1932. We had something called partnership deed, but here we have LLP agreement. Okay, let us see what this LLP agreement says. Mutual rights and duties of the partners within within the LLP are governed by an agreement between the partners. The LLP Act 2008 provides flexibility to a partner to devise the agreement as per their choice. In absence of any such agreement, the mutual rights and duties shall be governed by the provisions of LLP Act. Now, the striking feature of this act is that the positive feature it has not diverted from the Partnership Act in all the issues. It has retained the positive portions of the Partnership Act. Now, Partnership Act had a very positive vibe, had a very positive issue or a positive feature, that was it allowed flexibility to the partners to have to fix the relations between themselves, to fix their mutual rights and duties. And the act, that is the Partnership Act 1932, would have come into picture only in absence of an agreement. When there was an agreement, absence of agreement between partners, then the provisions of Partnership Act would have come into picture. Similar is the case here with the LLP Act as well. LLP Act also retains that flexibility which was provided by the Partnership Act. Now, even in the LLP Act, partners can decide their relations and their duties with each other in an LLP. There is absolute freedom here as well. Okay, and in case you people are not having something, you people have not decided your rights and duties via an agreement, then the provisions of Partnership Act will this LLP Act, Limited Liability Partnership Act 2008 will come into picture and guide you in that issue. Artificial legal person. This is a feature which is now borrowed from the Company Act. Feature borrowed from the Company Act. You read it and we will be back. So, this separate corporate entity is a feature, or artificial legal person is a feature borrowed from the Companies Act. NLLP, sorry, it has to be NLLP, is an artificial legal person because it is created by a legal process and is clothed with all the rights of an individual. Okay, just like a case of a company, an LLP is also a artificial person and it has all the rights which an artificial person can have in India. Okay, it can do everything which any natural person can do, except, of course, that it cannot be sent to jail, cannot take an oath, cannot marry, get divorced, nor can it practice a learned profession like CA or medicine. Something like this, okay, but ultimately it can do whatever a natural person can do. An LLP is invisible, intangible. Invisible means you cannot see it. Intangible means you cannot touch it. Immortal, it is just like Mr. India. Okay, immortal means it can be dissolved only by law alone. Partners cannot kill it, but not fictitious because it really exists. So it is invisible, intangible, immortal, but it is not a story. It is not a fiction. Okay, it is not a novel, but it is a reality which exists. Okay, and it is a artificial legal person, and it possesses all the features which an artificial which a natural person can do. It can do all the things other than some things which can be done only by a natural person, which we have written it here. Common seal. An LLP An LLP, being an artificial person, can act through its partners and designated partners. It can act through its partners and designated partners. So now we have something new that is called a designated partner. LLP may have a common seal if it decides to have one. So, like in the company's case of Companies Act now, we discussed that earlier companies were mandatorily having a common seal, but now that feature has become an optional one. Okay, in place of seal, a managing director or a company secretariat can sign. So now, similarly, in the case of a limited liability partnership act, limited liability partnership LLP can have its common seal if it wishes to have so, or it may not have if it does not want. Thus, it is not mandatory for an LLP to have a common seal. It shall remain under the custody of some responsible official, and it shall be affixed in the presence of at least two designated partners of LLP. So, if you are going to use the seal, okay, if the LLP feels that we will have our own seal, then the seal shall be kept with only a responsible person or the officer of the LLP, and seal can be used. This is the only restriction which we see on the user of seal, that seal has to be used only in the presence of at least two designated partners. Okay, two designated partners. Now, what are these designated partners? Okay, we will understand as we proceed in the chapter. Another feature is limited liability, like we discussed. Every partner of an LLP is for the purpose of the business of LLP is the agent of LLP, but not of the other partners. Section 26 says so. The liability of partners will be limited to their agreed contribution to the LLP. Management of the business. The partners in the LLP are entitled to manage the business of LLP, but only the designated partners are responsible for the legal compliances. Now you know what is a designated partner. Those who are tasked, those who have a job of making the legal compliance on behalf of LLP. Other partners can manage the LLP, but only designated partners can do with the legal compliance formalities. Management of the business. The partners in the LLP are entitled to manage the business of LLP, but only the designated partners alone shall do with the legal compliances. Minimum and maximum number of partners. Every LLP shall have at least two partners. Okay, every LLP now must have minimum two partners and shall have at least two individuals as designated partners. Okay, either these two can be partners as well as designated partners, or they can have more people to act as designated partners. Of whom at least one shall be resident in India. That means one has to be resident in India all the time. One has to be a resident in India all the time. Okay, resident means who is living in India for more than 183 days. Okay, there is no maximum limit on the partners in LLP. Like in the partnership, the maximum limit was put by the Companies Act, that was 50 partners. Okay, now this is a fresh change in the limited liability partnership, that there is no such ceiling on the maximum number of partnership. There can be any number of partners in the LLP as people find it fit. Business for profit only. This thing has not changed. This thing has remained same. The essential requirement for forming LLP is carrying on a lawful business with a view to earn profits. Now you are going to carry a business which is lawful and only with a view to earn profits. Thus, LLP cannot be formed for a charitable or non-economic or a social purpose. Clear? Even for the case of partnership as well. Investigation. The central government shall have powers to investigate the affairs of an LLP by appointing the competence authority for the purpose. Competent authority for the purpose. Okay, central government can set up a competent authority which will investigate into the affairs of LLP if same is required due to some suspicious activities of the LLP. Compromise or arrangement. Any compromise or arrangement, including a merger means into one. And amalgamation. What is amalgamation and merger? Merger means merging into something. Okay. Merger means merging into something. That means two or more partnerships into one. A, B, A, C, D, and D, E, F, and X, Y, Z. These are three partnerships. Now A, C, D, and D, R, F merged into X, Y, Z. That is called a merger. Now these two firms are gone. There is only one firm. That is called XYZ. That is called a merger. Amalgamation is ACT and DRF and XYZ. They all amalgamated and formed a new entity called ARZ. They have formed a new entity. Merger means some partnerships are merging into the other one. That means one will survive, others will lose their entity. But amalgamation means they are both amalgamated into each other. Now that means both have become one. Okay, there is no new entity. In amalgamation, a new entity is born. Okay, like VI, Vodafone Idea. It's an amalgamation. The new entity came into picture, that is called Vodafone Idea. Conversion into LLP. A firm, private company, or an unlisted public company would be allowed to be converted into LLP in accordance with the provisions of LLP Act 2008. Now we discussed it that it is providing choice to the firm or to a company or a unlisted public company that they can get themselves converted into limited liability partnerships if they choose so, and they'll have to follow the provisions of the LLP Act for doing so. E-filing of documents. E-filing means electronic filing. Okay, that is not physical filing. Physical means by hand hard copy. Okay, that is e-filing, only electronic. Every form or application of document required to be filed or delivered under the Act and rules made thereunder shall be filed in computer readable electronic form on its website www.mca.gov.in and is authenticated by a partner or designated partner LLP by the use of electronic or digital signature. That means now it has done away with a lot of paper clutter as well. Okay, earlier there was a requirement of filing each and every paper in a paper format, in a physical format. Now you are preventing that paper clutter or paper waste from occurring. Now you can do a lot of filings. Even you don't have to take transportation from one place to another. You can just easily simply sit in your office and log into this website and file all the papers electronically, and you'll have to use your electronic or digital signatures given to you. Foreign LLPs. Section 21M defines foreign limited liability partnership as a limited liability partnership formed, incorporated, or registered outside India which established a place of business in India. Foreign LLP can become a partner of an Indian LLP. Okay, like we discussed in the case of a partnership firm. A partnership firm could not have become a partner of another partnership firm. Okay, because the partnership firm had no separate legal existence. So when it had no separate legal existence, it could not have become a partner. Okay, but now LLPs, because they have a separate legal existence, then LLPs can have partnership with another LLP. And a foreign limited liability partnership is, as per the law, an LLP which is incorporated, formed, or registered outside India, but is having a place of business in India. Okay, but it is having a place of business in India. That kind of LLP shall be categorized as a foreign LLP, and now freedom is given to foreign LLP to become a partner with an Indian LLP as well. Now we'll discuss the advantages of LLP form. What are the advantages of the LLP? Okay, as a business model. Give a look to this flow chart and we will assemble within a minute. Now this is a flow chart which talks about the advantages of LLP as a form of business model. It is organized and operates on the basis of an agreement. Okay, LLP form of business is organized and operates on the basis of an agreement. It provides flexibility without imposing detailed legal and procedural requirements, like we just discussed. It is easy to form. All partners enjoy limited liability. It has a flexible capital structure, no minimum or maximum capital. Okay, it is easy to dissolve. You can bring it to an end. Okay, and you are not supposed to comply with tough legal formalities as in the case of a dissolution of a company. So these are some 6 or 7 odd advantages of the business model of the LLP. Now let us discuss incorporation of LLP. How an LLP is going to be incorporated. That means how you are going to create or give birth to an LLP in India. Essential elements to incorporate LLP. Under the LLP Act 2008, the following elements are very essential to form a LLP in India. Now these are the essential elements to form LLP in India. One is documentation. Definitely, first of all, we will begin with some set of papers. Okay, to complete and submit incorporation document in the form prescribed with the registrar electronically. Now we discussed everything is being filed electronically. So you'll file document as per what? As per required by the form prescribed. Okay, whatever is the format prescribed by the LLP Act, you will compile all those documents, fill all those forms, and file them electronically with the registrar, and your step 1 documentation is complete. Then we go to step 2, partners. To have at least 2 partners for incorporation of LLP. Okay, that is we have done. You need at least 2 partners. Okay, for setting up LLP or any other partnership at all, 2 partners have to be there. Registered office. To have a registered office in India to which all communications will be made and received. Okay, this is also very important that you must have a registered office in India. If you are not having a registered office in India, then your firm is not going to be registered at all. Designated partners. To appoint minimum 2 individuals as designated partners. And what these designated partners will do, who will be responsible for number of duties including doing all acts, matters and things as are required to be done by the LLP. At least one of them should be resident in India. That means they will act on behalf of LLP and they will comply with all the legal formalities of the LLP. They are designated partners and minimum 2 individuals should be designated partners. Minimum 2 should be there. Okay, and at least one of them should be resident in India. That means one of them is always approachable and is always available in India. That means you can have foreign partners as well, or partners which are not usually living in India, they are foreigner. Foreigners can also come in, join hand with Indians and set up partnerships as an LLP here. A very welcome shift. Deep in, okay, deep in meaning Designated partner identification number. A person or nominee of body corporate intending to be appointed as designated partner of LLP should hold a designated partner identification number allotted by MCA. So when you will apply to MCA, Ministry of Corporate Affairs, that I want to become a designated partner of some LLP, then a D PIN, that is designated partner identification number, will be issued and will be allotted to you. It is just like Aadhaar card, only one person can have a one kind of number. So D PIN is unique and it is allotted to one person only. Okay, one D PIN is allotted to one person alone, not to the LLP but to the person. Okay. Sixth is agreement. To execute a partnership agreement between the partners, inter se, okay, between the partners you will have a agreement, or between the LLP and its partners. So it is advisable that you have both kind of agreements. You have a agreement with the LLP as well as an agreement between the partners. You have both the documents ready in writing and signed by all the concerned parties, and it will be very beneficial for you in resolution of any future disputes which may arise between you and the LLP, or between one partner or the another partner. In the absence of an agreement, the provisions as set out in the first schedule of LLP Act 2008 will be applied. Like we discussed, the first schedule deals with the mutual rights and duties of the partners. So, if you do not have any agreement between the partners that these shall be the rights or duties of the partners, and this partner will have that role, another partner will have that role. Okay, if you do not have that bifurcation of business, you do not have that demarcation of mutual rights and duties in a written manner, then the first schedule of the LLP Act 2008 will be applicable upon you, and those rules will have to be followed by you. LLP name. Okay. The limited liability partnerships are bodies corporate and must be registered with the registrar of LLP, because they are body corporate. That means they have to be compulsorily registered. Okay. In the case of a partnership firm, registration was not compulsory, but LLP registration is compulsory. If it is not registered, the liability will remain unlimited. Okay. Only upon registration you will become a LLP, otherwise you will continue to remain a firm which is going to be unlimitedly liable even for the partners. After the following provisions specified in the LLP Act, in a similar way of setting up a company with a distinct name. It is just kind of a way of setting up a company with a distinct name, because company have suffixes like private limited, public limited, or something like this. It will have LLP written after it. Okay, like Bhargav and Anil LLP, something like this. The LLP cannot have the same name with any other LLP, partnership firm, or company. Okay, you should have a name and you should get yourself registered with that name. But that name should be unique as well. You cannot have a shared name. That means you cannot have the name which is already being used by a company or a partnership or another LLP. That kind of LLP you cannot have. To create a LLP, to create an LLP, Proper formation of documents must be filed with the registrar along with the necessary filing fees, and this is a process. Deciding partners and designated partners. First of all, you will decide who are going to be the partners, and out of those partners, who are going to be the designated partners. This is a decision which partners will have to take. Then you will have to obtain DPIN number and digital signature certificate DSC. DPIN number is relevant for the designated partner identification number. It is relevant for the designated partners, and digital signature certificate will be used by the DPIN holder director, okay, or partner. Then you will have checking the availability of name. Up to 6 choices can be indicated. That means you can give 6 choices in preference. Preference 1 is this name, preference 2 is this name, preference 3 is this name. You can give 6 preferences, and whatever name is available, it shall be allotted to you. Okay. Now, when you have decided partners and you have decided who is going to be designated partner, then you have taken a number for them, and now you have decided a name as well. Now, after that, you will draft a LLP agreement. Okay, you will draft an LLP agreement between you people, but this is optional. You may not even draft if you do not want to. Okay, if you do not have such kind of agreement between partners, then the provision of schedule first will apply. Okay, so you will draft a LLP agreement. Okay, after that LLP agreement, you will make an electronic copy of all these documents. Okay, and
It's
then
8 o'clock.
you will file it with the registrar. Then issuing certificate of incorporation along with LLPIN, Limited Liability Partnership Identification Number. Then after, if your all documents are in particular format, then the registrar will give registration to your LLP, and on the date of registration you will be given a certificate of incorporation along with a limited liability partnership identification number. This is just like a PAN number or Aadhaar card of limited liability partnership. It's a unique number. Okay, and from date of the incorporation, the LLP will come into reality, come into existence, and you can commence your business thereafter. Contents of the LLP agreement. What could be the contents of the LLP agreement? What could be added in the LLP agreement? Now, these contents are not mandatory. Okay, or it is not that only these many contents you can have. You can have some of them and some other which are not mentioned, or you can have all of these and not anyone else. Okay, it depends upon you people. This is just a for a kind of a reference. Okay, not a mandatory thing. You will have first of all a name of the LLP in the agreement. In the LLP agreement, you will decide the name of the LLP. Then you will mention the name and addresses of the partner and designated partner. You will write down who is going to the partner, and out of those partners, if someone is becoming designated partners or you have some other designated partners, then you will provide addresses for both kind of partners. Then form of contribution and interest upon contribution. Then what form of contribution is made by partners? If someone has brought money, you will write money. If someone has a commercial place of business, you will write it. If someone is bringing work, you will write it. If someone is bringing some patents or trademarks or goodwill, you will write it. Okay, if someone is bringing some expertise, professional expertise, you will write it as a form of contribution. And interest upon contribution. If you are going to pay some interest upon that contribution, if the LLP is going to pay some interest on that contribution, then you will mention it as well. Profit sharing ratio. Okay, because LLP is carrying out business for profits only. So when you are making profits, you must share the profits as well. So you will write it down, the profit sharing ratio. Remuneration of partners. Okay, if partners are going to take any salary, then you will write down the salary of partners. That is called remuneration, monthly payout. Okay, rights and duties of partners. Okay, what are the rights and duties of the partners in between them? Proposed business. What kind of business LLP is going to undertake? Is it going to be into legal business, or is it going to be into football business or cricket business or manufacturing, selling, retailing, whatever kind of business, filming, art and craft? You just tell the proposed business. rules governing LLP. Then you can frame up rules which will govern your LLP. That is just like you will frame up the article of associations of LLP. We have articles of association in the company, okay, isn't it? The articles of association in a company determine the rules of the running of the company, how a company will function. Similarly, you will have rules governing the LLP, how the LLP shall be governed. Now, steps to incorporate LLP. Now, these are the steps in which you will incorporate the LLP. The first step is to incorporate limited liability partnership is reservation of name of LLP. You will apply for a name, okay, and you will reserve the name for yourself. Then you will apply to the registrar that we have decided this name and the name should be reserved for our LLP. Then application has to be filed in e-form 1. There is a form number 1. Okay, in e format you have to fill that e-form 1 for ascertaining availability and reservation of the name of LLP business. Through this e-form 1 you will ascertain whether the name you want for your LLP is available or not, and if the name is available you will reserve the name for your business. After reserving a name, user has to file e-form 2 for incorporating a new limited liability partnership. Okay. After you have reserved a name, user will have to file e-form 2 for incorporating a new limited liability partnership. Then e-form 2 contains the details of LLP proposed to be incorporated. It will contain all the details of LLP, that is form 2. Partners, designated partners, details and consent of the partners, designated partners to act as partners, etc. All the thing. Then fifth step is execution of LLP agreement is mandatory as per section 23 of the Act. Now it is mandatory that you must have a LLP agreement, okay, because section 23 says so, but it is still optional that within that LLP agreement if you discuss the rights and duties of partners with each other or not, okay, that is still optional. LLP agreement is required to be filled with the registrar in e-form 3 within 30 days of incorporation of LLP. Now this form is to be filed with the registrar in e-form 3. You have third form number 3. You follow that format and you file it with the registrar within 30 days of incorporation of LLP. Okay, that means your LLP will be incorporated first, then you have to within 30 days file the LLP agreement. Okay, these are the stages which you have to follow in order to incorporate a new LLP. Please excuse me, we'll take a 5 minutes break here and then we will again assemble for the class. Differences with the other forms of organization. Now, how the LLP is different from other forms of organization. The points of distinction between a limited liability partnership and company are tabulated below. Now, we are going to discuss the difference between limited liability partnership and a company. Let us see. The basis. Regulating Act. LLP Act is regulated by LLP Act 2008 and the LLC. We are calling limited liability companies. Okay, or you can say companies. Companies are regulated by Company Act 2013. Members or partners. The person who contribute to LLP are known as partners in the LLP. In LLP, we have partners, but at the same time, in companies, the person who invest the money in the share are known as members of the company or shareholders. Okay. Internal governance structure. The internal governance structure of a LLP is governed by agreement between partners. Okay, there is an agreement between partner which determines the internal structure. The internal governance structure of companies is regulated by the statute, that is by a Companies Act 2013. Okay, we have flexibility here, but there it is rigidity. Okay, you are regulated by the statute, but here you can choose your own structure. Name. The name of the LLP to contain the words Limited Liability Partnership or LLP as suffix. In the end, ABC LLP or ABC Limited Liability Partnership you have to write so that people dealing with you know that the partnership firm has a limited liability principle. Name of the public company to contain the word limited and private company to contain the word private limited as suffix. Numbers of partners in a LLP. Minimum number is 2. And maximum no such limit on members in the act. The members of LLP can be individuals or body corporate through nominees. That means even body corporates through their nominees can be a partner in the LLP now. In private company, there have to be minimum 2 members and maximum 200. Public company, minimum 7 members, maximum no members. And members can be organization, trust, another business firm or individual. And here we can have a one person company as well, but we cannot have a one member partnership. Okay, we can have one person company, but we cannot have a one member partnership. This is also another form of differentiation. One person company can be there, but there cannot be one person LLP at all. Liability of members of partners. The liability of partner is limited to the extent of agreed contribution except in case of willful default. So he has agreed that I am going to contribute this much amount. Okay, but if the partner is found guilty of some willful fraud or willful negligence and the LLP has suffered some loss due to his willful acts, then his liability will be unlimited till the fraud. Okay, and in the case of company, liability of member is limited to the amount unpaid on the shares held by them. Okay. Now, management. What is the key difference in the management of both the structures? The business of company managed by the partners, including the designated partners authorized in the agreement. Now, you have an agreement. The agreement decides who will be running the business. But here, the affairs of company are managed by board of directors elected by shareholders. Okay, the affairs of companies are managed by board of directors, which are then elected by shareholders. Minimum number of directors or designated partners. There has to be minimum 2 designated partners for a limited liability partnership. In the case of a private company, you have to have minimum 2 directors. In public company, you have to have minimum 3 directors. Now, what is the difference between an LLP, a limited liability partnership, and a partnership? Let us see. Regulating Act. What is the regulating act of both the structures? LLP is regulated by the Limited Liability Partnership Act 2008, while at the same time, the partnership firm is regulated by the Indian Partnership Act of 1932. Body corporate. LLP is a body corporate, that means it has a separate entity. But partnership firm is not a body corporate as we have discussed. the partnership is partners only, no separate legal existence. Separate legal entity. It is a legal entity separate from its members. Okay. But a partnership firm is it is a group of persons with no separate legal entity. It is just a group of persons. That's it. But here LLP is a separate legal entity. Now, the difference on the basis of the creation. It is created by a legal process called registration under the LLP Act. You create LLP as per the legal process we just discussed above. Okay, following process for the incorporation of LLP. But the partnership firm, it is created by an agreement between the partners. Simply by an agreement, even registration is not mandatory at all in the partnership. Okay, you may not have even an agreement or you may not go for registration, but only by agreement you can start a partnership. But here, merely by agreement, you cannot start a partnership. You will have to get it registered as well under the LLP Act. Registration. Registration is mandatory. LLP can sue and be sued in its own name. So registration of LLP is mandatory. Without registration, LLP cannot come into picture. Registration is voluntary. Only the registered partnership firm can sue the third parties. Okay. Only the registered partnership firm can sue the third party, like we discussed in the case of Partnership Act 1932. Other party can sue you as a firm. But if you are not registered, firm cannot sue third parties in the name of firm. They'll have to use the name of directors, or sorry, partners only. Perpetual succession. Perpetual means unlimited, endless, timeless. The death, insanity, retirement, or insolvency of partners does not affect its existence of LLP. Members may join or leave, but its existence continues forever, like we just discussed above. The death, insanity, retirement, or insolvency of the partners may affect its existence. It has no perpetual succession. Okay, the partnership has no perpetual succession. Okay, it can be brought to an end anytime. It is very easy. But here, it is perpetual existence, and only through following a legal process you can bring it to an end. Name. Name of the LLP to contain the word limited liability partnership as a suffix. No guidelines, the partner can have any name as per their choice. There is no guideline here in the partnership. You can have any name you want to have. Liability. Liability of each partner limited to the extent of agreed contribution except in case of a willful default like we discussed above. Liability of each partner is unlimited because a partnership is a unlimited liability partnership. It can be extended up to the personal assets of the partners. That even personal belongings of the partners could be sold off in the market. Mutual agency. Each partner can bind the LLP by his own acts but not the other partners. Now the liability of partner is towards the LLP here only and not towards the other partners. But here each partner can bind the firm as well as the other partner by his own acts. See how flexible this LLP has become now. Whatever were the flaws or the ill points in the partnership have now been corrected by the LLP. Now there is mutual agency between a partner and the LLP, but not between a partner and the partner. In case of partnership, there is an agency between partnership and the partner plus partner and the partner as well. Okay. Designated partners, at least two designated partners, and at least one of them shall be resident in India. Now, this is a requirement that you should have at least two partners who are designated partners, and at least one of them shall be resident in India. If you look at the Partnership Act 1932, there is no such provision for such partners. That means all can be remaining, all can live in the foreign as well. In the Partnership Act, all partner can live in foreign, may not come to India. Common seal. It may have its common seal as its official signature. There is no such concept in partnership. Legal compliances. Only designated partners are responsible for all the compliances and penalties under this Act. Only designated partners will be responsible for the compliances as well as penalties under this Act. All partners are responsible for all the compliances and penalties. Here, all partners are responsible. Here, only designated partners. Annual filing of documents. LLP is required to file annual statement of accounts statement of solvency, annual return with the registration of LLP every year. So these are the set of documents which an LLP is supposed to file every year. Partnership firm is not required to file any annual document with the registrar of firms. Okay, this what document partnership firm is required to supply with the registrar is sometimes when there is a change of the nature of business, or when there is change in the name of partnership, or when there is change in the constitution of partnership, then only. But here you have to make some annual filings, which is not very tough job, only that is just for the regulation purpose. Foreign partnership. Foreign nationals can become a partner in a LLP. Foreign nationals cannot become a partner in a partnership firm. Okay. Foreign nationals cannot become a partner in partnership firm, but Indian nationals can become a partner, and they can then live in foreign, may not come to India, but they continue to be Indian citizen. So they can have this kind of partnership. Here, foreign nationals can also come and be a partner in LLP. Minor is a partner. Minor cannot be admitted to the benefits of LLP. LLP minor has no scope at all. But here we discussed that a great detail of chapter was dedicated to the entry of minor as a benefit partner. Okay, minor can be admitted to the benefits of the partnership with the prior consent of existing partners. These were the difference between LLP and the partnership. So with this now our course for the LLP is complete, and as well as our CA course is complete. I wish you all the very luck in CA examination. Thank you.